What happens when the Supreme Court denies key Second Amendment cases but leaves the biggest ones hanging in the balance? That's exactly what we're going to dive into today. If you care about your constitutional rights, especially the right to keep and bear arms, this is an update you don't want to miss. This morning, 2 Second Amendment cases were denied cert. At first glance, this might sound like bad news, but trust me, it's a lot more nuanced. The most critical 2A cases, Snope v. Brown and Ocean State Tactical, are still alive and well before the court. That silence from the justices might actually be a good sign. Today, I'll break down what happened, what's still on the table, and why this could set the stage for a pivotal moment in Second Amendment history. Stick with me, because by the end of this, you'll understand exactly why the fight for our rights is far from over. This morning, the Supreme Court issued its cert denials in 2 Second Amendment cases, Maryland shall issue and Gray v. Jennings. Let me explain why this isn't as devastating as it might initially sound. The first case, Maryland shall issue, revolved around a licensing question. Essentially, it challenged whether Maryland's process for issuing firearm licenses violated Second Amendment rights. Now, while the issue itself is significant, the court likely saw this as something still percolating through the lower courts. In plain terms, they're probably waiting for a better case, or maybe a more compelling angle, to make its way up. The second case, Gray v. Jennings, was more procedural in nature. This case asked how courts should handle preliminary injunctions in Second Amendment cases. Now, don't get me wrong, procedural issues matter. They often shape how constitutional rights are enforced, but this case wasn't a blockbuster in terms of immediate impact. So why were these cases denied? It could be that they didn't present the clean slam-dunk opportunities the justices prefer when taking on landmark issues. Remember, they have thousands of petitions to consider, and each grant represents a major investment of the court's time and resources. The real takeaway here? Neither of these cases pose the monumental questions we're hoping to see answered. The denial of cert might feel like a setback, but it's not the end of the road. The big ones, the ones that can redefine Second Amendment jurisprudence, are still very much in play. Now let's talk about the 2 cases that really matter, Snope v. Brown and Ocean State Tactical. These are the heavy hitters that could reshape how the Second Amendment is interpreted across the nation. First up, Snope v. Brown. This case comes out of Maryland and challenges the state's AR-15 ban. Maryland's law essentially prohibits one of the most popular and versatile firearms in America, labeling it an assault weapon. The question at hand is whether such a ban violates the Second Amendment as interpreted in District of Columbia v. Heller and more recently in Bruin. The stakes here couldn't be higher. If the Supreme Court grants cert and rules in favor of Snope, it could set a precedent protecting semi-automatic rifles nationwide. Then there's Ocean State Tactical, a case out of Rhode Island focusing on so-called large-capacity magazines. Let's be real, what they're calling large capacity is what we know as standard capacity for modern firearms. This case questions whether Rhode Island's ban on these magazines passes constitutional muster. If the court decides to hear this case, it could force states to reevaluate similar bans across the country. The fact that neither of these cases was denied cert is significant. It suggests the justices see something worth considering, or at least worth taking more time to deliberate. That silence speaks volumes. These cases are likely being relisted, giving the clerks and justices more time to dig into the procedural and jurisdictional details. Here's why this matters. If cert is granted in either of these cases, it's a sign the court is ready to take a hard look at these overreaching gun control laws. And given the current composition of the court, the Second Amendment community has every reason to be cautiously optimistic. To understand what's happening with these cases, we need to talk about the Supreme Court's cert process. It's not as simple as the justices just deciding to hear a case. There's a lot more going on behind the scenes. When a case is petitioned for certiorari, the justices and their clerks go through it with a fine-tooth comb. They look at the case's legal questions, the arguments made in the lower courts, and any potential procedural issues, like standing or mootness. Chief Justice John Roberts, in particular, is known for being meticulous about ensuring cases are procedurally airtight before the court grants cert. Now, when a case like Snope v. Brown or Ocean State Tactical isn't outright accepted or denied, it's often relisted. That means it's put back on the agenda for further review. This gives the clerks and justices more time to assess whether the case has any fatal procedural flaws or jurisdictional defects. Relisting can happen multiple times, so patience is critical here. Here's where things get interesting. The fact that these two cases are being relisted is actually a positive sign. It indicates the justices see enough merit in these cases to warrant closer examination. They're likely weighing not just the specific issues at hand, but also the broader implications for Second Amendment jurisprudence. This process can take weeks or even months before a final decision on cert is made. But make no mistake, every additional review increases the likelihood of a cert grant. If the court takes on Snope or Ocean State Tactical, it means they're ready to tackle some of the biggest constitutional questions surrounding the Second Amendment. So while it might feel like we're in a holding pattern, this is the critical part of the process where the groundwork for future victories is laid. Stay optimistic. This kind of silence often means something big is brewing. Let's talk about where things could go from here. When it comes to Supreme Court cases, there are several possible outcomes, each with its own timeline and implications. The best-case scenario? The court grants cert in Snope v. Brown, Ocean State Tactical, or both cases as early as next week. A cert grant would be a game-changer, signaling the justices are ready to take a deep dive into these critical Second Amendment issues. If that happens, we could see oral arguments scheduled later this year and a landmark decision by mid-2025. The second-best scenario is that these cases are relisted again. While that might sound frustrating, it's not unusual. Sometimes, the court needs additional time to resolve procedural questions. If this happens, we'd likely see a decision on cert in late January or early February. It's slower, but it still keeps the cases alive. Now, the worst-case scenario would be a denial of cert. If that happens, it could mean several things. The justices weren't confident in the procedural setup, or they weren't ready to address the broader Second Amendment questions raised by these cases. In that event, these issues would need to work their way back up through the courts, which could take years. There's one other possibility worth mentioning. The court could decide to punt these cases to the next term, which begins in October 2025. This isn't ideal, but it's not unheard of, especially if the justices feel they need more time to thoroughly review the issues or if they want to align these cases with others that could create a broader framework for Second Amendment rulings. At this stage, all eyes are on the court. Every day that Snope and Ocean State Tactical remain in play is a victory in itself. For now, we wait and hope for the best, because the outcome of these cases could define the Second Amendment's future for generations to come. The stakes for Snope v. Brown and Ocean State Tactical go far beyond just Maryland or Rhode Island. These cases have the potential to set national precedents that could fundamentally reshape Second Amendment rights in America. Let's start with Snope v. Brown, the AR-15 ban case. If the court grants cert and rules in favor of gun owners, it could signal the end of state-level bans on commonly owned firearms. Think about what that means. The AR-15, one of the most popular firearms in America, could be fully protected under the Second Amendment. Such a ruling wouldn't just affect Maryland, it would force states like California, New York, and others with similar bans to reconsider their laws. This would be a monumental win for the 2A community. Now take Ocean State Tactical, the magazine ban case. Standard capacity magazines are vital for self-defense, competition, and everyday gun ownership. A favorable ruling here could strike down restrictions on magazines in states across the country. This would solidify the idea that the government can't arbitrarily limit the tools Americans use to exercise their Second Amendment rights. But the implications go even deeper. These cases could also clarify how lower courts should interpret the Supreme Court's Bruen decision. In Bruen, the court emphasized a text-and-history approach to evaluating Second Amendment cases, but many lower courts have been resistant to fully adopting this framework. A ruling on Snope or Ocean State Tactical could reinforce Bruen and ensure that courts apply it consistently. Beyond the legal impact, these cases could also influence the political landscape. If the Supreme Court strikes down these bans, it would send a powerful message about the limits of government power and the importance of individual rights. It could energize the pro-2A movement and shift the conversation around gun control nationwide. This is why these cases matter. They're not just about one firearm or one magazine. They're about affirming the fundamental principle that the Second Amendment protects individual rights. The outcomes here could shape the future of gun rights for decades, and that's why we need to stay informed and engaged. To wrap things up, let's take a step back and look at the bigger picture. Right now, we're in a critical moment for the Second Amendment. Two major cases, Snope vs. Brown and Ocean State Tactical, are still alive at the Supreme Court. While some other cases were denied cert, these two have the potential to reshape the legal landscape for gun owners across the nation. We've talked about what these cases mean, how the cert process works, and the possible outcomes we might see in the coming weeks. The best-case scenario is a cert grant, which could lead to landmark rulings on AR-15 bans and magazine restrictions. Even if the court decides to relist the cases again, it's still a sign that they're taking these issues seriously. As we wait for the court's next move, it's important to stay optimistic and focused. These cases represent an opportunity to solidify the Second Amendment's place in American law and push back against overreaching gun control measures. But remember, the fight for our rights doesn't end here. It's an ongoing battle that requires all of us to stay informed, engaged, and ready to act. Thanks for tuning in to this update. If you found this helpful, make sure to subscribe to the channel and share this video with others in the 2A community. Together we can make sure the Second Amendment stays strong for generations to come. Stay safe, stay vigilant, and I'll see you next time.